contract has its price. You can't get something for nothing. Hi, I'm Chandani and this is Logical Lens. And here we connect law to people one basic at a time. And today we are decoding the consideration.
So, what exactly is consideration? It's not about being polite, it's a legal concept and a crucial one in contract law. Let's break it down. In simple terms, consideration means something in return. It could be a benefit to one party or a loss to another. For example, if A sells his car to B for rupees 2 lakhs, B's money is A's consideration and A's car is B's. Simple give and take. Now let's get legal. Section 2 Clause D of the Indian Contract Act 1872 defines consideration as an act, abstinence or promise made at the desire of the promiser. This is key. If there is no desire from the promiser, there is no valid consideration. Before we go deeper, let's get a basic terminology right. Who is the promiser? The one making the promise. And who is the promisee? The one receiving it. Simple but important. First essential. The act must be done at the promiser's request, not voluntarily. In Durga Prasad versus Baldeo, the court said no request is equal to no consideration. For example, A builds a market on his own, B later promises to pay. Not valid because B never asked for it. Second essential. Consideration does not have to come from the promisee, anyone can give it. In Chinnaya versus Ramaya, a third party was allowed to sue because he wasn't part of the contract. For example, A gives land to B and tells her to pay rupees 500 to C. C didn't give anything, but he can still enforce the promise. Third essential. Consideration can be in the form of the past, present, or future. Let's say A saves B's life. Later, B promises to pay. This is past consideration, already done, but still valid under Indian law. Moving on to the fourth essential, that is, consideration can be an act like doing something, an abstinence like not doing something, or a promise to do either. For example, if A agrees not to sue B in exchange of rupees 50,000, that's a valid consideration too. The fifth essential. Consideration must be real. You can't base a contract on something imaginary, like if it rains purple. That's not happening and neither is your contract. Courts won't enforce vague or impossible promises. The sixth essential. Consideration must be lawful. If it involves something illegal like paying to someone to smuggle goods, the whole contract is void. Law doesn't support deals that break the law. And lastly, consideration need not be adequate. It means fairness doesn't matter, existence does. You can sell a rupees 5 lakh property for just rupees 5,000 and the contract will still be valid as long as there is some consideration. Courts do not judge how good or bad the deal is. Let's recap. Consideration is defined under Section 2 Clause D of the Indian Contract Act 1872. To be valid, it must be at the desire of the promiser, given by the promisee of any other person, can be past, present, or future, may involve an act, abstinence, or promise. It must be real, not imaginary, and lawful, and need not be adequate. It just needs to exist. That's your complete checklist for valid consideration.
That's consideration. Clear, simple, and sorted. Keep learning law one concept at a time only with Logical Lens.